None of those. Question on notice 19.1 deals with Crozier Hill Estate. That's from Councillor Charles. A recommendation that Council note the information and commentary provided in this report regarding Councillor Charles' report titled Matters Arising in Connection with Crozier Hill Estate, Victor Harbour, presented by Councillor Peter Charles in the City of Victor Harbour Council on the 26th of September 2016, and that no further response to the report or the questions posed be sought from administration. Someone like to move that way, thank you. Councillor Jenkins, thank you. Councillor Chigwin, second. Open for discussion. Anyone against?
Excuse me, Mr Mayor, I respectfully raise a point of order.
What's your point of order?
Point of order. Who set the motion? Was Councillor right? This motion is not in keeping with the provisions of the Act, and I ask that Councillor Jenkins retract her support for the recommendation, as is clearly ultra vires. With regard to the final 16 words they are, that is the 16 words of the recommendation, and that no further response to the report or questions be sought from administration. This is an unlawful attempt to circumvent the Local Government Meeting Procedures Regulations and the Local Government Act of 2002. Elected members, as we know, this part of the Act under the heading of Section 9, Questions and Subsection Regulation 1, a member may ask a question on notice by giving the Chief Executive Officer written notice of the question at least 5 clear days before the date of the meeting at which the question will be asked. If notice is given under subsection 1, which is what I just read, then part 2A, the Chief Executive Officer must ensure that the question is placed on the agenda for the meeting at which the question is to be asked, and part 2B, the question and the reply must be entered in the minutes of the relevant meeting. Members, we all will have to turn our minds to the fact that the Act means what it says. That is, according to the information I shared reading from the Act just a minute ago, if the questions are placed in the agenda, and they obviously have been, then it is unlawful if they are not answered in the minutes. Therefore, so as not to act unlawfully, in 5 days these questions should be answered and printed in the minutes. I also remind members that Part 4, Section 91 of the Local Government Act, Point 3, each member of the Council must, within 5 days after the meeting of the Council or Council Committee, be supplied with a copy of all minutes of the proceedings of the meeting kept under this section. As you would know, Councillors, Section 9, Part 2.6 is quite clear. The presiding member may rule that a question, with or without notice, not be answered if the presiding member considers that the question is vague, irrelevant, insulting or improper. In simple terms, these 4 words which describe the intent, real or perceived, are the only reasons upon which answers will not be provided lawfully. Note the questions are asked, but in the assessment of the presiding member, the decision to answer or not is vested. There is no provision in the Act to remove the lawful right of an elected member to put questions to administration, and no provision for administration to not provide answers, unless the questions are once again deemed vague, irrelevant, insulting or improper by the presiding member. Mr Mayor, you are the presiding member. How say you?
Thank you for that, but I will point out that the questions deal with a subject matter which Council has already ruled not to receive information on. And it's my recollection that the information you passed to me was just on the end of the last meeting, and was just handed there with no comment from Council. I'll be guided by our CEO on that matter. Is that your recollection of the last meeting?
Well, through you, Worship, I think Councillor Charles probably raises more questions than answers at the present time, and perhaps it is best for Council at this point in time to adjourn this particular item, receive Councillor Charles' professional legal opinion, if that's where he's got it from, and for Council to seek its own legal advice on how we can proceed with this matter.
Yeah, thank you. Yes, Councillor Marshall?
I can't believe what I'm hearing. I think every elected member in this council swore an oath to look after the interests of the ratepayers. For someone to try to tell an elected member of this council that there are certain questions they just can't ask, I think is just reprehensible and beyond the joke. I don't think we need to seek legal advice. Why do we always have to go and spend money on legal advice? Yes, about the rocks, that's good value, but not about this. What concerns me is the end of the motion. It says, and that no further response to the report or the questions posed be sought from administration. Now, does that refer to elected members? Does that refer to members of the public? Who does it to the media? Who does it refer to? I mean, you're trying to say here that we are omnipotent. We are not going to listen to your questions, and that's it. And I just think that's totally wrong. And if anyone believes that, well, I think they need to put in their resignation.
Thank you. Yes, Councillor Schofield?
Can I just make a statement? Look, I read through this. I have looked at emails, read letters, and I believe that this debate's been going on for the past 6 years. There have been around 40 court cases resolved in the council's favour, numerous complaints lodged to a number of bodies and organisations. After 6 years, the accusations towards council remain the same. The findings provided by the investigation into the accusations have remained the same. What are we proving by continuing to pursue this issue, and at what cost?
Thank you. Yes, Councillor Andrews?
Point of order, Mr. Chairman.
Sorry, Councillor Marshall, you've spoken.
A point of order.
Yes, your point of order.
I believe Councillor Schofield is misinformed. This matter is a new matter. It's nothing to do with what's been discussed over the last few years. It's a matter that was raised by Councillor Charles. It's nothing to do with the Blatchford issue, nothing to do with ponds. It's an entirely different matter.
Well said, Bob.
We'll just move on from that point of order. Yes, Councillor Andrews?
Right.
This may or may not be worthwhile to consider, but what is our legal obligation regarding protecting our administration from vexatious or harassment via questions, either from members or from the gallery? Because I believe we have a legal obligation to protect them, and also, of course, to give them a safe environment.
Can you cover that for us? Thank you.
Well, all I can, thanks you, Wish. All I can respond to in regard to that is that yes, elected members have a responsibility to staff under work health and safety, a very serious responsibility under work health and safety. I think the report here has been quite encompassing in terms of advising the elected members what's happened previously, what's happening now, the level of scrutiny that these issues have received, and the resource required for council to actually go back now and start again from scratch and review many questions which have already been asked. I believe you can argue, Councillor Charles, that this has nothing to do with Blatchford issues. However, your document refers considerably to Blatchford issues, to extracts from emails between council and Mr Blatchford, to issues associated with various allotments on Stock Road and the original subdivision. I agree, the original subdivision and other development within that subdivision are not directly related to that Blatchford, but certainly have been asked and answered previously. And in fact, were referred to in a number of the ERD court proceedings which occurred. We had to provide substantial documentation to the courts in relation to the activities and decisions in Stock Road.
Yeah, thank you, Graham. You've already spoken to Councillor Charles.
Well, I'll put in the point of order then. Maybe I'll get an opportunity to just clarify that when it comes to staff and embarrassment of the council, I refer to Part 3, Section 94, that is Part 4, in considering whether an order should be made under subsection 2 is irrelevant that the discussion of a matter in public may cause embarrassment to the council or council committee concerned or employees of the council, or cause a loss of confidence in the council or council committee. This is quite clearly will apply to questions as well. I'm afraid it has absolutely nothing to do with the pond. The pond was taken to court and that's the end of the story. That's what it was all about, 40 trips to court over the pond. I have other people supplying the information now. You can imagine after 2 years, people are coming out of the woodwork and I have plastic bags full of information. Yes, I'm able, because I am able to consult with Mr. Ben Blatchford for some information, but his document that he presented to you people is completely different to the one that I worked on and had done for me. Legal advice, that's another story, but I categorically deny that my interest in this development, which has taken place in the floodplain, is about one resident. And if it were, that resident is still my responsibility, and everyone's. All of it, all for one and one for all, according to my duty and principal role of council, to act as a representative, informed, responsible decision maker and interests of my community. I believe I've undertaken my responsibility in informing council and the community of my concerns and taken positive steps to encourage an inexpensive, low-key, local approach involving polite and respectful discussion, but I feel my motives and integrity have been called into question. The incredibly detailed document that involved in a total dedication of time to prepare apparently is not worthy of discussion, and my lawful questions up until this point are unanswered, which is unlawful regardless of the vote to be taken in the next minute if it is. Always remember my first concerns were brought to council and it was I who spoke of the desirability to build bridges and to seek mediation. It is not, and if it is necessary for me to look at other options, I will.
Yeah, thank you. I think at this stage of way forward may be that this matter lay on the table and council seeks legal advice on the matter. I'll be guided by elected members how that works. You're happy to move that way, Councillor Jenkins?
I have to move that.
Thank you.
Doesn't matter.
Well, I can make a ruling on that, can I?
No, only a member who hasn't moved or seconded the motion that's currently on the floor can seek to adjourn a matter.
Okay.
Could I have a question, please?
You've made a comment.
Could I have a question, please?
Question?
Question. How much are we thinking of spending on legal advice on this? Because if you're saying that this is the same matter as the Blatchford matter, we've already spent $500,000 on it and got really nowhere. All the advice that I've ever had on this matter has been behind closed doors, with notes unavailable to the people who are being addressed. And if you want to relate it to this, Mr. Blatchford was never allowed to be in the room and to argue his case. So I'm really worried about spending more and more money on lawyers. It just seems that some people think that it's an inexhaustible supply of ratepayer funds to spend on lawyers, which I think is just appalling.
Thank you. A way to move forward. Who hasn't spoken on this matter? Councillor Hales and Councillor Gillespie. Have spoken on this matter? If there's no other way forward, I'll put the motion. Councillor Hales, yeah?
I guess I will move that, not that this question lie on the table, but this be adjourned to our November meeting to be addressed then.
Yeah, just vote that out first.
Yeah, thank you.
Point of order.
We need a second.
Councillor
Seconding that? Councillor Gillespie, you happy to second that?
Since it has to be me, by the sounds of it. I will second it, and I will say something. Probably get myself into to trouble. Am I allowed to speak to that, or is there some rules? No? Okay.
Thank you. Thank you. Everybody understand this last motion? All those in favour? Those against? That's carried. Thank you.
Do you mind if we have a division on that, please?
Councillor Charles has called for the division. Thank you. All those in favour, please stand. Councillor Schofield. Councillor Andrews. Councillor Hales. Councillor Jenkins. Councillor Glazebrook. And Councillor G. Whitman.